Why aren't we just making our privacy notice just really detailed at this point? It's something we all need to be aware of, is that just because the state privacy law doesn't provide a private right of action doesn't mean that there's not another workaround. Organizations cannot just rely on a good DPA, a good contract with their third parties.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, good. We've got Monica Meiterman here today. She's a partner at Tueoris, which is an international privacy and security consulting firm, and she's based in Barcelona, in Spain. Monica helps global clients in developing, maintaining, or growing their privacy programs with an in-depth understanding of US state-level and federal requirements, as well as the GDPR, PIPEDA in Canada, or even the Brazilian framework. Monica advises on specialized matters in the AdTech space, like advertising, analytics, AI, or industry guidance like the IAPP framework. She is a member of both the New York and New Jersey state bars, as well as chapter chair of the IAPP in Barcelona, which is how we met. Today we'll do a deep dive into data subject requests, whether it's access requests, portability, or even withdrawing consent. We are focusing primarily in the US, but we will use the GDPR and AdTech guidelines as a reference point as well. Let's go for it. Monica, thanks for joining me.
I'm honored. I'm honored to be here. Thank you for inviting me.
Well, thanks for making it. Okay, so data subject requests. They come in many flavors. What is the most interesting part from your point of view?
The area that I think is most interesting right now is I actually read this term in the California regulation, the guidance that they provided about providing users with this like frictionless, frictionless rights, making sure, and it was in the context of opt-outs, but I think that term is something that I really encourage, and I'm seeing shockingly a lot of my clients interested in, is providing the frictionless experience for consumers. And I just think that's such an interesting space because we're right now, especially in the US, we are towing the line between whether or not that's even required. But I'm finding organizations are kind of volunteering and taking that extra step and investing more in their program so that consumers do in fact feel in control of their data, not just in the context of like, oh, I can get access to it, but I can opt out on the front end and back end quickly. I can delete my data on my own. I don't need permission. So I think that seeing that shift has been really interesting. I think that also seeing how privacy tools are trying to catch up to that interest is really interesting. But just that whole conversation around really giving consumers true, meaningful choice, not just the perception of choice. That's something that I've been really, really digging into with my clients. And it really, as a privacy professional, makes me super happy to see that that's the conversation, as opposed to the former, or I think the public perception that organizations want to just grab and hold on to as much data as possible and just let consumers think they have control. I don't necessarily think that's where we're at anymore for every organization. And I think that's really interesting to be a part of that solution building.
Yeah. So you've seen how things evolve in the EU, and there's been plenty of fines coming, from all directions about Article 15, for example, like right of access and the others. And then the US, you've seen, as you say, you've got California, and then it's propagating right throughout the different states. So, what framework do you use as a baseline? Would you rather provide differentiated levels of control as a company expands into different states or as those issue new privacy laws? Or do you go all the way to applying GDPR standards, for example, and forget about fine tuning to keep as much data as possible?
Like the EU residents do have much broader rights and it's a lot scarier. But in the US, if you started with, oh, just California, and then now you're expanding to the next set of laws, and then 6 months later, the next set of laws, I think that it's become really tedious. And I think from every side, right, the legal team trying to anticipate it, the developers that we have to rely on to build out these tools, to the extent that, you're automating in any way, everyone, I think there's just a bit of a fatigue. And so I think and also then seeing, some of the regulators in the US start to express, we're looking into these things, we're investigating, maybe like, sending notice, it's starting those conversations of, okay, do we really want to do this 50 times? Is there a way that we can start to build a more robust program where consumers truly feel in control and we don't have to change one thing here, one thing there, new state here, new right there? Like one thing that really provoked this conversation, which is really silly, but that Oregon law about providing a list of third parties, it just kind of, are you familiar with that?
Yeah.
Yeah. So that one for one of my clients was like, oh, like, why aren't we just making our privacy notice just really detailed at this point? Because now every new state is going to ask us to provide this little information, that little information. And it started a conversation of having a very detailed, transparent privacy notice that I wasn't even the one to encourage it. I mean, I obviously support it, but they were the ones that came to me and were like, we don't want to have to keep doing this. Like, we don't care about, we have nothing to hide. Let's make it clear. And so I think that feeling, that sentiment is spreading all over the privacy program of we don't want to have to keep doing this. And for the organizations that do feel a certain sense of responsibility to their consumers, they're looking for the way to skip all those steps and just provide the consumer with that feeling now. I don't know if that answers your question, but I think that's kind of the journey I've seen.
Yeah, so the journey towards the highest standard.
Yeah, exactly. And I think that not even the highest standard anymore. I think some organizations are just trying to do some trending. They're looking at the trends and they're seeing, we think this is where it's going anyway. As a consumer, we're having those conversations too, where it's like, okay, forget about where you work. As a consumer, if you went to another organization, what would you hope for? And using that to kind of dictate how you can treat your consumers. And the truth is, even with the most robust DSR program, making it the easiest, frictionless, we're not seeing such an increase in requests coming in. So it's not hitting the business that hard, but or for some of my clients, I should say, but it does make them look so much better from the consumer perspective, from the regulator perspective. They're doing the right thing, and it's not really changing their business that much. So it really is a very worthy investment of time to really see what is the bar that we're comfortable reaching, and can we go a little bit higher, and can we, it's a long-term investment.
Very good. So, in the EU, something that's been a big headache has been this, which is how far do you go to identify a data subject before you share whatever you've got about her? And there's been fines in one direction. So, a fine, for example, I think it was 1&1 in Germany, the ISP back in like 2019, and that fine was issued, I mean, for a few reasons, but one of them was that you would just approach them with a simple date of birth and a name, and they would tell you everything they've got about you. So you would be able to get data about, your ex whatever. It was just open. And so they issued a fine. And then there was the opposite fine, which is that I believe it was Groupon. They were asking for too much information. And there's been specific statements from the member states saying you should not be requiring people to, to show an identity card as a precondition to exercise their rights. So what do? If you ask for too much, then you're going to get a fine. And there's a few already. If you ask for too little, then you're going to get a fine because that's a data breach. So there's a sweet spot where you need to know that you're dealing with the right person. And then there were these guidelines in the EU, and so now I've got them here. There's guidelines from March last year, so guidelines on data subject rights, and they were trying to help people understand how far to go with IDs. What's your experience in the US? Do you think self-service is solving for that problem?
Yes, I think so it's a conversation that I have constantly, right? How far to go, how much can you trust before you hand that over. I think that for the organizations that can afford it, the privacy tools are taking that burden away for a lot. There is the validation tools that you can have them validate their email and confirm that they in fact have access to that email address. But there's limitations even there, right? If your main source of identity for that user is not an email address, right? If that's not the core of your communications with them, then what do you validate with, right? Or if you can't afford to have a tool like that, then what are you left with? So those use cases can be really challenging. And to your point, yeah, I think every organization it's a special case because you have to understand what their relationship is like to the user. To your point though about self-service, I think that self-service for a lot of different aspects of privacy have taken the burden off of the controller and really given control to the consumer, which I think some of my clients feel like that can't possibly be enough. But the truth is, I think, isn't that the goal in the end, right? Isn't the goal to just allow the consumer to do what they want with their data? So a lot of my clients that are shifting to this, you can export data on your own, click this button, and we'll send it to your email address. That is just the gold standard as far as I'm concerned, right? You don't have to touch it. They have to validate themselves. And, it's about as simple as that. So I think that a lot of my clients, to the earlier discussion, that are trying to kind of go back and do privacy by design, 2.0, right? They're trying to rebuild the tool so that the privacy is first. They are trying to create those experiences for their users, right? Where they can delete their data on their own with a certain level of oversight or export on their own. And it definitely it takes out a lot of the questions of am I doing too much or too little as far as validation goes? Because it's definitely a big concern. And especially, some of my clients, what they're collecting is nothing that is so, it would be so egregious in, I don't know, like watch history for something, nothing so scary, but still it's PI, but it's the ones that have clearly very, very sensitive information. They are super, super nervous about sending it to the wrong person, that they're even not comfortable relying on a validation tool. They still want to request that additional piece of information, but what is it? What is too far? So we have to do those kind of risk analyses based on what their relationship is with the consumer, what kind of data they hold about the consumer, what tools they have, and then go from there to build the perfect solution for validation so that they feel confident before they send it out.
Yeah, it's so tricky. And so in the self-service world, so whatever you can do on self-service, there's an advantage, another advantage is that, yes, that data minimization principle, since you are relying on whichever identifier you initially used to, again, to create my account, for example, if it is built on top of a cookie, then the cookie being present is enough for me to retrieve that data because there is only that much. Why ask me for an ID if all you've got is basic signals about my activity?
Right.
If the data you've got is tied to an email and I've got my email address and I can verify it, that should be enough to then pull from that. If you've got more, again, like a phone number, so the good thing about it is that it sort of matches the depth with which you know the data subject.
Exactly. Exactly. Yeah. And, I've had some clients, I think rightfully, everyone's a little skeptical. And so they'll say, well, is it enough that if they have access to that email address that I can trust it's them? What if they got hacked? And I've had that conversation with a few customers and it's, there comes a certain point where you can only do so much. if they've got hacked, they have to take that up with their own email provider. But it does speak to how concerned again that my clients are that it's going in the right hands, and are we doing enough, right? Are we doing enough diligence before we release this information? And I always appreciate them being that thoughtful. But to your point, right, if it is commensurate with the relationship you have with the client, then it should be sufficient as long as you have a certain level of confidence that no one else is submitting this request on their behalf.
Yeah. And then, since more and more states are expanding the range of rights, then yes, you were mentioning the ability to download all of your data. So then we're combining access rights with portability rights where they exist. In the EU, they do not exist all the time. You need to be relying on contractual legal basis or consent. So if portability happens, then in the same effort, you can access and download your data. How do you see that combination of access and portability in the US? Is there an expectation that goes beyond access and amendment or corrections into portability? Is that spreading?
Yeah, I guess the emphasis in the US has always been so much of just providing the users with access. And I do feel that in practice, they are kind of becoming one, the rights, right? They're being treated similarly. And yeah, it's kind of gone beyond the point of having distinct processes because it's kind of like how, I mean, it's separate, but similar analogy of like a lot of organizations where someone's opting out may choose to just also go and delete, right? They're just saying like they've made it clear what they want, let's follow through. And so if a user's asking for access or portability, regardless, they want to see their data and they want to do something with their data, so let's help them do that. So I think that it's going again, kind of going beyond the semantics of well, oh, an access right is this, and this, and portability is that. No, they want their data, right? So let's help them. And I think that's the conversation I'm always trying to have. So yeah, I would say to your point, in the US, the conversation isn't so separate anymore. It really is just one combined right. And to the point where when you look at DSR forms or you look at any kind of intake space, you're not always seeing like access, delete, portability. You're seeing provide a copy of my data, remove my data, right? They're getting to the point of what does the consumer want? Don't make them look up definitions of what an opt-out is, what a deletion is, what anything like that. Just say what they want and let them do it. And so, yeah, it's just becoming really friendly, I think. It's just people are kind of lifting the veil and saying, we know what you want, and here it is.
Yeah. And I see California, Colorado, Connecticut, Virginia, all of them have portability. And I'm not familiar with how deep they go.
On that note, something that we've started doing, or I've started to encourage my clients to do, is take that one next step where it's not just sending them an export or an attachment of their data, but also providing, we're calling it a key, but providing an additional document to explain to them what are they looking at, because sometimes it's just a bunch of numbers, it's a bunch of dates, right? And maybe there's some categories, but the categories are in code language.
Yeah, it's a log or an XML file or something really, really ugly.
Yeah, exactly. Exactly. And so technically it is machine readable, right? Like they can look at it, but do they know what they're looking at? So for the clients that are feeling really ambitious and they're really open to these conversations, we're putting together a key that we're attaching, saying, here's your export and here's what it means, so that they can look and see exactly what it is that we've shared with them. For some exports, it really is so the key is either really short or it's all data that we know they don't care about, but at least they know, right? They don't feel like we're trying to mask anything. And so again, further diving into that transparency conversation, I think it's been a really valuable tool.
Yeah, some people can get very nerdy with that. I've seen people visualizing that data on database tools, like more advanced tools, to sort of download your Spotify data, download your Google Maps data,
Yeah.
overlay them, and start visualizing that data. That is, in fact, the output, the result of you exercising your portability rights. But not everyone is that nerdy. I'm sure there's tools as well for whoever wants to, you know, to pay
Yeah,
and
I'd love to play around with that. That sounds very
well,
cool.
a colleague of mine at IE University is teaching data visualization with that, with exports from. those kinds of data sets. Okay, so then what happens? Let's move on from self-service, right? So self-service, or maybe one last question about self-service. In the space that I work with a lot, which is marketing technology, MarTech and AdTech, but mostly MarTech. In MarTech, there's all of these suppliers, cloud-based platforms. They are the ones that are processing the data on your behalf if you're the data controller. And so there's no efficient way to do this unless you can ping their so-called APIs, right? Their APIs, their application programming interfaces. So you can ping that API, make a request with an identifier, and then that data comes back to you. So there's an effort in data integration. It sounds very simple, but many vendors have to pay. So meaning it has a cost to make these calls to the APIs. Have you had that conversation maybe with where automation sounds great, but we're hitting costs in the sense of, again, third parties involved?
Yeah, that's for sure one of the major blockers regarding automating any of the processes, right? The clients that I have that are using a lot of external organizations or vendors. So the places where we've successfully implemented something self-service are generally those organizations that are maintaining the data internally already, not leveraging as much externally. And so we're able to really chase down all the data within internal systems, whether it's because that data has already been brought back into the organization for other purposes, and it's great. We can leverage that for access, which was a big one for one of my clients, right? They were already kind of all pulling in the data, and we hit a gold mine, right? We were able to just do it all with an internal database. But regarding the ones with a lot of external vendors, those are the ones that are still relying on a semi-automated process. Semi-automated meaning they can pull certain amounts of data on their own, but then, someone has to go and collect everything else, package it up nicely and share it. And so, yeah, it's certainly a restriction. That we're navigating. And I think as like contract renewals are coming up, my clients are hoping to kind of tackle that discussion and say, how can we have a more seamless relationship regarding DSRs, especially access, obviously access being the most difficult of all of those. So to your point, definitely a huge blocker that should not go, untalked about because organizations may be listening and thinking, well, I want to do that. That sounds super easy. And it's, there's still a lot of legwork to do and maybe costs associated with it. You're absolutely right.
So then if you move beyond that, beyond automation, recently there was a fine, since you're based out of Spain, Iberia, the airline. So they received this fine. It's not much, but it's 40,000 euros. And it is directly tied to Article 15, so right of access. And so I haven't read it, I'll tell you. I only found it on the enforcement tracker website, right, on
A
the
great
database.
site.
I found plenty for Italy, but in Spain there was this one. So Iberia, well known, the sort of the flagship airline, and that's from this year, so February this year. And what I understand is that it is about the opposite process. So a manual effort to hand over someone's data once they wrote to the DPO. That is a big pain. So even if you automate everything, you may still be getting an email or, according to the Spanish agency, a WhatsApp that you need to reply to. There was another case somewhere, I can't remember now, where you were expected to respond via WhatsApp because that was the customer support channel that had been enabled. And so you need to be open to all of these channels so as to answer a DSR or a DSAR. What do you think is an efficient way to tackle this? If they can come from all angles, any tips?
In the US, it's a lot, I find it's a lot simpler. I think in the EU, because you are obligated to provide all those avenues, it's certainly a little bit more sensitive. But my guidance to clients is to have that
Yeah,
centralized
yeah,
intake point for DSRs, right? So To the extent that, like, if you have customer service teams and you have someone manning the privacy inbox and you have all these different people, I think the first line of defense when someone reaches out regarding their data is saying, we, respect your privacy and we want to give you control, blah, blah, blah. Please fill out this form and try and encourage them to fill out what that centralized intake form is. And this is obviously, again, for those clients that have the privacy platform, that has the validation in it, all of those fancy tools. It's a really good way to funnel everyone into the same place so that you know you're tracking their data. The thing is that not everyone wants to be cooperative and wants to fill out that form, and that's what you have to prepare for is yeah, what do you do if they respond and they say, I don't want to, I can't. Do you say to them, as an organization, are you comfortable saying to them, like, this is our process, you have to fill it out, otherwise we can't honor your request? Or do you have alternative manual processes? And that's kind of where things start to deviate. So I think in an ideal world, um, everybody is, responded to in the timely manner, and they're told, please, for your safety and security, please fill out this form because we can validate your identity and we can, treat your data with sensitivity. And hopefully they're open to that. But for the ones that aren't, then yeah, you have to go that next level to figure out how do I validate them if they don't want to use the form, if they don't want to get the validation email, right? How do I do all of that? And that starts to unravel that conversation we were having earlier about what's too much, what's not enough. But I think that as a simple response, I do try to create a centralized, some kind of intake form, whether it's truly like a Google form that leads to a space or a privacy tool, ideally. What's your take on that, though?
I need to see how this stands against time. But for now, my take is volume determines everything. So if you see that very few people approach you asking for the data, and that the usual scenario under which the usual sort of background to people asking for the data is a customer support challenge, which is very common, especially in Spain, where people find, that they cannot move farther when it comes to customer support. Sometimes there's even an element of sort of even revenge, against the system that treated them badly. So if you look at all these tiny little fines in Spain, you know that you can find a lot of the motive behind it very often is a customer support ticket gone wrong,
Hmm.
gone the wrong way.
Right.
If that's the case, then I think you need to go and tackle the source of the problem. So there was an issue with customer support, and then someone couldn't, they found they were not being treated properly. So then they start asking and they start writing to the DPO at mailbox. And then it's all about, so I look at volume. If you get lots of people asking for the data, I think that's a good sign that you need to start installing something, some sort of self-service tool. That's a good sign, right? Yeah.
Yeah, I mean, and just as a comment to those that don't have the budget or the bandwidth for a tool, I have seen and I've worked with clients, we have gotten very creative. We have used, free tools out there. Like I mentioned, there's Google Sheets or Microsoft or anyone that has their own form you can create. There's project management tools. So we've used Airtable, Asana, Monday.com, these project management tools that allow you to create forms and you can keep track of DSRs. And then there's obviously the privacy tools, but the spectrum is very wide as to what it is. Even an emailing platform for a marketing team, we were able to leverage that into a DSR repository. So you don't need to have anything too fancy. You just need to have the interest and you need to have a little bit of time to build it out. But it does save you a lot of juggling later on if you have a centralized place. So you can definitely get creative. That's something I always try to encourage. I'm not the person to push for a privacy tool off the bat, especially for smaller organizations. But I do think it's worth investing some time to be really intentional about. And to your point earlier, this is something that it always comes down to this because you were discussing how it starts with one bad customer support, interaction. Just as an organization in general, you want to just avoid disgruntled consumers, right? And that's why that I think is like the essence of everything I've been saying today, right? Is make the consumer feel they are in control. They have all the information they need to understand what's happening with their data, and that they certainly have the control over their data. If someone comes to your site, your platform, or interacts with you, and they start to sniff out that you're not trying, you don't want to help them, you want to hold on to their data, you're making it difficult, then they're going to complain, they're going to ring the alarms. So to the extent that you can avoid any kind of disgruntled consumer, you are protecting yourself, greatly, especially in the EU where there is such a heightened response to the data subjects complaints. In the US, it's a little hit or miss whether or not you'll hear back, but in the EU, they're going to come knocking. So I just think that, one thing I always discuss in addition to the back end process of what are you doing when you get the request is what does the user journey look like when they want to, uh, request access to their data, request deletion. They want to opt out. In the US in particular, the opt-out journey for me is huge. If anything is buried, you're creating problems for yourself. It doesn't need to be the first thing they see. It's more of a business decision a lot of the times, but don't make it difficult. And so that's something that I just encourage so highly. And we're seeing it globally, right? If you make them angry, they will come back 10 times harder. Just work with them, make them feel safe and in control.
Yes, I was also thinking the system will penalize an older company with legacy systems because for all the simplicity involved in building some tools, and I agree, it's so easy to come up with something creative of your own. You do not need to buy a fancy tool. There's so much, and I also think that no matter what you buy, it's all down to your systems because they are the ones that have to be integrated. So if you've got a backend that is really convoluted and legacy systems, crazy, a very, very hard to crack backend, that's going to make it very hard. How are you going to query that to then, allow people to access that data? If you're all a newer company where everything is using new standards, where everything is cloud-based in a way that it's super interoperable, it's so easy to make a query against three different systems and it's come up with a summary. Also, in the EU, we cannot leverage plenty of the things that you mentioned, right? In the US, for example. So whenever you start talking about all of these tools that make your life easier, like Airtable, for example. Airtable is a very good example. Super flexible. You can do so much with it because it's processing data in the US. I once asked Airtable whether there was a chance to process data in the EU, and there wasn't. And so these days we're okay because we've got a data privacy framework. But once you've got a tool like that and you've got an EU-based customer, then there's the additional question. I'm building a tool for customers to exercise their rights, but that tool may be challenged because it is processing data in the US. And maybe in a couple of years, if we have a Schrems 3, it's going to need some sort of new standard contract clauses, and it's another headache. So that's an advantage that we've got in the US.
It's a really good point, Sergio, honestly. But yeah, I mean, I think there's probably comparable solutions in the EU, but to your point, if you're a global organization, it may not be as simple as picking one tool that can be used globally. You have to think about who's going to be accessing it. So, an incredibly valuable point.
Well, thanks. And so, Monica, is there a private right of action of any sort in the US? Do you see a risk of it coming around the corner at some point of someone being sued because a consumer couldn't exercise? Could we get to that extreme?
Well, looking at how the plaintiffs bar has been so creative in the US, I wouldn't write off anything. I think they are very actively looking for ways to bring class actions for privacy rights, even when it's not under a privacy law, right? So you're seeing those really interesting SIPA claims and or lawsuits being brought under old wiretapping laws, right? And
Yes.
they're really the foundation is it's current privacy rights, but they found these old laws and dusted them off and said, we're coming for you. So who's to say where they're digging next to find it? I would say, yeah, it's something we all need to be aware of is that just because the state privacy law doesn't provide a private right of action doesn't mean that there's not another workaround that's, around the bend. So, especially for anyone in the media space, anyone that has, videos playing or even just a chat box on their website, it became very abundantly clear that it's not just the privacy laws, it's not just the FTC, it's the whole book. And these plaintiffs bars they're creative. So yeah, I would say I'm looking forward to whatever their next creative venture is for
Yes.
sure.
So, any last tips?
So I think that just one thing that I'm seeing as a trend, and I think again, it's not just limited to DSAR, but it is just it's the US I'm seeing replicate in the EU, right? So this is a trend that I think is really interesting is the obligation we're seeing on businesses or what would be the
Yeah.
controller, right? We're seeing such a shift in what the expectations are around controllers, the diligence that they're required to perform, and the responsibility that is being put on them, even for actions that in theory used to not be theirs, right? Whether it's a breach downstream, but they didn't do the right diligence. Now you're being investigated. Or, for DSAR, I can see a world where now these controller businesses are in fact being investigated because, they communicated a deletion request, but the vendor didn't honor it, right? I can see a world where now businesses are responsible for so much more than their contract says. And so I think that just as forward thinking, organizations cannot just rely on a good DPA, a good contract with their third parties, right? I think, and that goes with the whole business, the whole privacy program, right? You should really understand who you're working with, understand what they're doing, and you should have that good relationship with your vendors before you share data or before you start sending DSRs or anything of that nature. You need to be really confident in your position, and you need to actually do the work. Just having a shell of a vendor assessment is not enough. Just having a good agreement is not enough. You have to put the work in. And I think that bleeds into so many parts of privacy compliance right now. So that's just the trend I'm seeing.
Thank you. That's such a good point. I see it all the time as well. Third-party audits, vendor reviews, super important. Well, Monica, thank you very much. Thanks for everything.
Thank you for having me. This was such a interesting, compelling conversation. I have so many things, so much homework to do after this conversation.
Same here.
But hopefully I get to see you soon.
Thank you. I hope so too. Okay, that's all for today. Please follow the Masters of Privacy channel on LinkedIn if you want to find some interview transcripts, cheat sheets, and other useful resources and surprises every now and then. On top of that, episode notes and other feeds are available on mastersofprivacy.com. Thank you for listening.